Everyone, I'm Tamron Hall, the News Nation. It's following continuing developments in the wake of the George Zimmerman not guilty verdict. One of the 6 jurors announced today she is now dropping plans to write a book. Juror B37, whose identity is being kept secret for now, issued a statement saying the isolation of being sequestered, quote, shielded me from the depth of pain that exists among the general public over every aspect of this case. She also said, quote, the potential book was also always intended to be a respectful observation of the trial from my and my husband's perspective solely, and it was to be an observation that our system of justice can be so complicated that it creates a conflict with our spirit of justice. Now that I am returned to my family and to society in general, I have realized the best direction for me to go is away from writing any sort of book and return instead to my life as it was before I was called to sit on this jury. That is her statement. Well, the development follows the juror's extensive interview on CNN where she discussed jury deliberations, including the initial vote.
We had 3 not guilties, 1 second-degree murder, and 2 manslaughters. I was not guilty.
Because of the 2 options you had, second-degree murder or manslaughter, you felt neither applied.
Right. Well, because of the heat of the moment and the stand your ground. I mean, he had a right to defend himself. If he felt threatened that his life was going to be taken away from him or he was going to have bodily harm, he had a right. It's a tragedy this happened, but it happened. I think both were responsible for the situation they had gotten themselves into. I think both of them could have walked away. It just didn't happen. I feel sorry for both of them. I feel sorry for Trayvon and the situation he was in, and I feel sorry for George because of the situation he got himself in.
We also heard today from George Zimmerman's parents.
That we are deeply sorry for this tragedy. Deeply sorry. We pray for Trayvon Martin to be in a better place.
What do you want to say to your son?
That I love him with all my heart. That I'm sorry that it has to come this way. Painful for the whole family. But the truth will set you free. And that's, what I had been living and waiting for. The truth will set you free, George. And that's what it did.
Meantime, new rallies today in wake of the verdict, including this one that got underway in just the past hour in Houston, Texas. And in Washington, civil rights leaders, Reverend Al Sharpton, who also hosts MSNBC's Politics Nation, announced plans for nationwide protests this weekend.
On this Saturday, we have called for a national Justice for Trayvon Day. In 100 cities, people will gather in front of federal buildings and federal courthouses for 1 hour to have rallies and vigils calling on the Department of Justice to resume aggressively a civil rights investigation in this matter.
And joining me now live, our panel for this hour, Sirius XM Michael Smerconish, who's also an MSNBC contributor, Pulitzer Prize-winning columnist and associate editor of the Washington Post, Eugene Robinson, who's as well an MSNBC political analyst. Also, civil rights criminal attorney John Burris. Thank you, gentlemen, for your time. John, can I start off with you here because the juror said the initial vote, 3 not guilty, 1 second-degree murder, 2 manslaughters. Help us understand, with the experience you've had, how someone would go from second-degree murder to a not guilty. We're not talking from manslaughter to not guilty. This is second-degree to not guilty.
Well, she could have certainly felt the evidence at the outset that that's how it appeared to her. But the other 3 people who were not guilty, any one of them could have been much stronger in terms of their commitment to not guilty. And it sounds like one person was. And what happens, they start deliberating and they start showing them the evidence and they go to the jury instructions. The jury instructions may not have been given clearly at the time. And so once you go to the jury instructions and this lady says about stand your ground and the heat of the moment, they had zeroed in on the most important aspect of the case from their point of view. And when you do that, then the other jurors who may be manslaughter, who may be second degree, could easily not hold their positions. And I think when we had to reread the clarification on manslaughter, I think jurors at that time were the more for guilty verdicts were really trying to persuade the manslaughter people that it did not apply because of the self-defense component and the heat of the argument. I think the part in that is more critical is that George Zimmerman had the bruises and the lacerations on the back of his head, which clearly suggested he was in a fight, and then they also believed that the scream. So the heat of the battle, obviously, it was a critical point.
I guess, John, what I'm trying to understand, and I don't pretend to understand the situation these jurors were in and in the thought process, but I've got to figure here that at the end, after the closing arguments, you're not digesting the entire testimonies that you've heard. You've been digesting and listening throughout. And so for the initial gut reaction from one of the jurors to be second-degree murder and back down from that, or at least be persuaded by the other jurors, is that something that you often see? Oh,
absolutely. It happens often in cases, and that's not surprising. The initial verdict, initial discussion might have been very early, or it could have been after a brief discussion of the facts. But ultimately, there's going to be someone in there who is a leader who will ultimately control that discussion point and will bring the facts to the other people to support their position. So it would seem to me that the not guilty people really had the stronger positions there on self-defense.
Let me bring in Eugene here. Eugene Robinson, you wrote this article, Black Boys Denied the Right to Be Young, and you go into great detail on how young black men, the assumption is often one that is dehumanizing, that they're not allowed, or young black men like Trayvon Martin are not allowed to be children. But I want to play the juror's response to the question regarding race and her not feeling that race played any part in this case. Let me play it.
I don't think it did. I think if there was another person, Spanish, white, Asian, if they came in the same situation where Trayvon was, I think George would have reacted the exact same way.
Now, Lisa Bloom also has an op-ed, Eugene, and she talked about lawyers were free to use profanity involving the case, but would not use the R word, that the R word was off limits, meaning race. Should this juror, I guess, have been worldly enough to connect the dots here, or was that the responsibility of the prosecution?
Well, I thought the prosecution left some pretty big dots, you know, in its description of the way George Zimmerman had pretty evidently profiled Trayvon Martin as, you know, and these guys, these punks, they always get away with it, and did, in my recollection at least, they didn't totally ignore the race issue. I suppose you could argue, you could envision a sort of alternate world prosecution in which that had been made a more central factor, and it certainly was seen as a central factor to most people, or many people, from the beginning of the case. Perhaps prosecutors were nervous about that and wondered how that would play and whether that was the best strategy to get them a conviction.
Well, Michael, I'm going to bring you in, and this is going to be awkward for me, but I'm going to put it this way. There is a saying, you might hear it from time to time, where folks will say it's a black thing you don't understand. And a lot of people are saying that so many parts of this case are difficult for some whites to understand, particularly Rachel Gentile, who I had the pleasure of meeting a short time ago. We were set to interview her, but through scheduling problems, we weren't able to bring that. But I met her, and here's what the juror, who spent far more time with Rachel Gentile, at least in contact, had to say about her. Let's play it.
I didn't think it was very credible, but I felt very sorry for her. She didn't ask to be in this place. She didn't ask. She wanted to go. She wanted to leave, and she was embarrassed by being there because of her education and her communication skills, that she just wasn't a good witness.
Is this a white-black thing?
Definitely. And I remember having a conversation with you close in time to when Rachel Jeantel was testifying. And I said, Tamron, I just discussed this on radio, and my callers broke completely along racial lines. The people who were calling and were white versus those who were calling and were African American, seeing this entirely different. If you'll permit me, in that same interview with Anderson Cooper, the juror then said, I really don't think it's racial. This is about Rachel Jeantel. And she said, I think it's just everyday life, the type of life that they live, and how they're living in the environment that they're living in. And when I read that, I circled that in the transcript.
Forgive me for interrupting, but she also went on to say she didn't even understand how they were talking, some of the words, as if, and this is why I always rejected this notion of ebonics, as if there is some foreign secret language that different groups share, and that others are left out of this intimate circle.
Right, and so when I read that and what you're making reference to, I said, okay, this juror and perhaps these other jurors who were not people of color, as you know, fell into the category that many whites fell into when they looked at Rachel Jeantel and other aspects of the case.
Okay, Michael, again, because we have such candid conversations, here you are, white male, nowhere close to her age, meaning Rachel Jeantel, her demographics, her background. You got her. You understood her.
Well, I got her, but I have to. But Tamron, I have to tell you, there were aspects of her testimony that I questioned, because the fact that she was more forthcoming after that initial interview than she had been in the initial interview gave me some sense of trepidation.
But isn't that a technical question? Isn't that technical, as opposed to saying she's speaking a language you don't understand, or going to her education? Because we know that a young black girl is not the only uneducated person, if that is what she is, and I'm not saying that is what she is.
I can only speak for myself and say I was not dismissive. I was not dismissive of her because of the way in which she spoke, nor the mannerisms that she exhibited. I was totally hung up on the nuts and bolts of what she was offering in her testimony.
Eugene?
And that's absolutely proper. That was absolutely proper to focus on what she said and how that affected the case, rather than the way she said it. I too have seen this complete split in the way whites and blacks have reacted to Rachel Jeantel's testimony. I just did a live internet chat, and I was getting questions from both sides about her, and as if they're living on different planets.
This is why you needed African Americans on the jury to offer real explanations and understanding. Because the testimony was credible about the conversation she was having, but if you couldn't understand it because of lack of association with that community, then you would reject it, and that's apparently what happened.
Let me play what the juror said regarding the 911 tape. I was struck by her conviction and her certainty of the identity of the person screaming. Let me play that.
I think it was George Zimmerman's.
Did everybody in the jury agree with that?
All but probably one.
And what made you think it was George Zimmerman's voice?
Because of the evidence that he was the one that had gotten beaten. Because the witnesses of John Good saw Trayvon on top of George, not necessarily hitting him because it was so dark he couldn't see, but he saw blows down towards George. And he could tell that it was George Zimmerman on the bottom. He didn't know who it was, but he knew what they were wearing.
John, does this go again back to what you identify with? And I said it that day when the defense chose to show a particular picture of Trayvon Martin with his cap on backwards with his shirt. It really was saying, what do you identify with? And here this juror seemed to identify certainly with that testimony and her certainty, again, without any proof that it was George Zimmerman's voice. It's one thing to say a witness saw this or witness heard this, but she said, I am certain that it was George Zimmerman.
Well, I have to tell you that given the logic of what was taking place and the positioning, I mean, it's easily logically to assume that it was George without knowing more, given the position. If you accepted John Good's testimony, it would have been easy for you to conclude that it was George Zimmerman's voice. And the certainty of it is kind of shocking, but it also meant to me is that the mothers and the family members were all not accepted as being viable truth takers, sayers on that issue. I think they followed strictly from the fact that John Good's testimony suggested that George was on the bottom, and the person on the bottom is the likely the person to be asking for help, and he had the bruises to go with it. So that part is not difficult to appreciate in terms of their conclusions.
Sherilyn Eiffel is the president and director counsel of NAACP Legal Defense Fund. She joins us, gentlemen. Sherilyn, thank you for making time. Here's the deal. I am curious, and you heard John Burris bring up the issue of diversity among jurors. And I just had someone tweet me basically saying, get over it. Can't we move past race? And I'm curious when people have that reaction, because how do you move past something that you haven't dealt with?
I completely agree, Tamron. You know, if there's anything that this case teaches us, is that we are not ready to move past race. I think there are a number of people out there who, because they are made uncomfortable with what is genuinely an uncomfortable conversations about race, they would rather not have them, and in fact they would rather pretend that race and racism and race in the criminal justice system is not a reality. Even the judge, you know, forbidding the use of the term racial profiling, you know, played a role in trying to marginalize the issue of race in a case that I think most Americans actually think did have to do with race. The whole conversation you just had about Rachel Gentile and whether she was understood and whether people got her was less about whether they understood the words that she said and more about how they responded to the physical cues, the dialectical cues that are all racialized. And so race was at the center of this case and remains at the center of this case. And that's okay. That can happen. When you have a young African-American man who's shot under these circumstances, of course race is going to be part of it. The problem is our failure to openly and candidly engage the issue of race so that the jury would have had to grapple with their own potential prejudices, the potential prejudices of George Zimmerman, the realities of what would have made Trayvon Martin afraid when he saw a man who he thought was a white man stalking him on the street. Those are all realities of this case that should have been candidly engaged so that the jury could have weighed it properly.
And real quick, I'm out of time, but Eugene, I want your final thoughts on that. When we talk about candidly discussing race, how do you keep people from pulling it into this so-called race baiting upon the mention of the R word, as Lisa Bloom, who is white, called it in her op-ed in the New York Times?
Right, and so that's where we go. I mean, I think this is the way we have the national conversation about race, unfortunately. We don't all sit down on a given day and have a measured discussion. Something happens. There's an event, there's a trial, there's a shooting, there's a something, and we argue about it, and we fight about it, and we talk about it, and we get it kind of all out, and then after a while we stop talking about it, and hopefully we've learned something, and we've made progress. It's not an easy way to make progress. It's not a comfortable way to make progress.
The question, though, is who's talking about it. We're talking about it, but that doesn't mean the people like on the jurors, the people who are on jurors like these ladies, are they talking about it?
Well, we heard the juror say in her latest statement is that her eyes basically have been awakened to the pain that this case has caused. So what she did not see as a race issue while sitting in that room, it seems certainly it has come full circle to her now. And we'll see if she, well, I don't want to speak too much for her. I don't know her, but at least that's part of her statement there. Thank you for your time. I really appreciate it. It's an important conversation.